assault between the two.
I do everything in my power to try to prevent people from going back into custody. But some people just refuse to just, I don't know what I can do to get your attention. You now have 2 open cases, and now this is your second bond violation. What do I need to do to get your, what do I need to do to get your attention? Is it putting you back in jail, Mr. Joseph, and making your bond high?
Sir.
Your actions tell me differently. This is what we're going to do. I'm sending him now for a drug and alcohol test. I want to know what, if anything, is in the system. You were to come back. If you fail the test, if you fail to take the test, if you fail to come back, it's not going to go well for you. Do you understand? I don't want you to say anything. I want you to go take.
I'm offended. I don't get this. We don't have no time for the to get on my system.
You have been on bond, Mr. Joseph.
Okay, so now yeah.
I think the last time he was in court, Judge, I think he made an admission that he had used drugs during that court appearance. And if that's the case, he may be correct in that it may still be in his system, Your Honor, because it hasn't been 30 days.
The first burglary motor vehicle has been open since June of 2024. Since that time, I have told you not to use.
Okay, how?
Take a seat for me. I don't know what we're gonna do. Take a seat.
Thank you, Judge.
You were here in June last year. You have a violation because you came in late then. Now we have another set of bond violation for you coming in late.
Was he,
Why would I continue to let you go? I let you go already once and you did it again.
instead of voting, we'll put it on Thursday.
Do you see what I mean? Because me, if I let you go, then I'm telling you it's okay for you to do what you're doing, when it's not.
Judge, if I may, I believe that he has a legitimate reason. I believe that if he had not gone, there was the possibility that an assault or some other harm could have happened to his girlfriend. From my conversation with Mr. Joseph, he informed me that he left, and it was just for only 24 minutes. He left in order for both of those parties to cool down before a fight or an act of violence escalated between those two parties. I personally think that that was the right thing to do.
Hold on a second. Who do you live with at home?
My girlfriend, but my sister stay right down the sidewalk in the same apartments.
You stay in a complex.
Yes, sir.
She doesn't live with you.
Huh?
She doesn't live with you.
No, not my sister.
So who is the fight with?
It's my understanding that it was his girlfriend.
Is it the family here?
My girlfriend here.
So the fight was with who?
It wasn't a fight, it was a words that was about to escalate into a fight, at which time he left for a cooling off period with his girlfriend. And she left, something serious could have happened. I believe that was, even though it was a violation of the bond condition, I believe that it could have been worse had he not left.
If you put your hands on anyone, I don't care who it is, if it's a woman, if it's a man, I'm gonna put my hands all over you. You understand?
Yes, sir.
Nothing in this life can justify you putting your hands on anyone. You have
Man, my
two.
hands on her. I just left so the situation can cool down.
You have 2 open cases. At all times, you need to be thinking to yourself, if I do this, what's going to happen? If I say this, what's going to happen? If you're going to antagonize, meaning if you're going to say something that makes someone flip out on you and the laws come over and they see you and they look you up, 9 times out of 10, they're going to go against you. You need to be thinking of these things at all times. You get into a fight with them, words, it's always going to end up bad for you. I understand and I appreciate de-escalating the situation, meaning you're leaving so that it doesn't end up in anything more. But it shouldn't be like that in the first place. Are you working?
No, I just did 3 job applications. I'm waiting on the interview to
Mr.
begin.
Judge, yes, sir, I know you are.
I don't care.
I do, Judge.
Why aren't you working?
I just recently started looking for jobs.
You have too much time on your hands. You need something to do in this life before it takes you down. When you have too much time on your hands, you become self-destructive. You need something to do in this life. It's time for you to start working. And I want to see that you get a job. Toria, can we help them out?
Yes, I'll give them some resources.
We're going to give you resources to try to help you get a job. There's no reason why you can't have a job within the next couple weeks if you try. When you put your heart and soul into it, you can achieve damn near anything. It's just how badly do you want it? That's what it amounts to. And when you do get a job, if you really do a bang-up job, and if you do well, and you don't do stuff half-assed, all you're going to do is you're going to go up, and you will make more money. The higher you go up in a job, the more money you're going to make. And then everybody's happy. When you get to buy nice things, that's what life's about. Not the janky, stupid-ass jobs where you're making $6 an hour. No. Work hard so you can make a lot of money. All right.
It's great.
I'm not going to ding you. I don't want any more issues. Do you understand, Mr. Joseph?
Yes, sir.
I'm bringing you back in 2 weeks, and I want to see that you have a job. 2 to 3 weeks. If I see that you haven't put any effort into it, it's not going to go well between us. I also don't want you to use any dope. Do you understand?
Yes, sir.
If I find that you're testing positive, likewise, it won't go well for you. All right, Mr. D.
Thank you, Your
You're
Honor.
good.
This Miranda warning moment is critical probable cause must be established before moving forward. The judge is ensuring constitutional protections are followed.
Just approaching on a new fugitive case, it's Robert Mizell. And Judge, he would like to have a bond set. It's kind of an odd one, Judge. It's failure to possess the required license for home improvement or residential construction. And basically, Judge, he told me that he owned a construction company, but he's totally blindsided by this charge.
Good morning, Mr. Mazzell.
Good morning.
Your lawyer's asking for me to set you a bond. You
Yes, sir.
now stand charged with, I guess you said, home improvement fraud.
Judge, essentially, that's what it sounds like the allegation is. It's a failure to possess the required license for home improvement.
I have your fraud.
This was in 2020, during the 3 hurricanes that hit Louisiana. And according to City Hall, and we went down to everybody, and they said we didn't need one because it was an emergency situation. Everything was flooded and devastated, and we were just trying to help out.
My only issue is that this is now a second fugitive case that you have.
The first one was a lady that we did work for.
Let's be careful.
Doesn't matter.
Oh, sorry.
This, Mr. Mazzell, is that, we usually, as a matter of courtesy, I guess, so to speak, we'll give you a chance when you get one fugitive case. But we can't continue to do the same thing over and over and over.
Understood.
Amy, what do you know anything about this?
Yes, so first off, state is opposed to a bond. This particular case is because he didn't have a license, but it originated out of the fact that the complaining witness, after a hurricane, had paid the defendant money to repair her house. He did not do so. The money amount was
So he allegedly took money for fixing the house and didn't do the work.
Correct. And then when the officers went to go look him up, he didn't have a license under that name. So that's the basis the basis for that charge. We are, of course, opposed to a bond given that he has had a prior fugitive case. He was granted a bond on that one, but he didn't actually show up. Looking back at our notes. The only
So
reason.
we gave him a bond, he bonded out and he didn't show up?
No, he appeared,
No.
yes, he appeared in court on that day when you guys provided him a bond. He appeared in our court here in Harris County.
Okay.
The only reason that case was dismissed is because I believe that the main jurisdiction in that case had recalled their warrant or something of that nature.
But so he didn't turn himself in.
No,
The lady that was charging us, I ended up paying her $21,000. And she dropped the case.
How? I suppose, we can't just take everybody's word for what they
But
say.
first off, I did not know that even the warrant existed. So I had no idea. But I ended up paying the lady off. I gave her some money and said, okay, that's good, we're fine. Because I truly didn't think we did a very good job.
Okay.
But may I ask you this? This is an LLC. I have a business, or had a business partner at the time. We were 50-50 in the business. I just wonder why I'm the only one being charged here. I mean,
Facts beyond what I would know anyways. The simple thing about it is that I gave you a bond last time. You bonded out,
yeah,
you didn't show up, and now you have another fugitive case. We can't continue.
I bonded out and I paid the lady off and she dropped the charges.
That case was dismissed? Is that
Yeah, the
correct?
case was dismissed.
Not because he showed up like he was supposed to.
I see what you're saying,
He
Judge.
came to court on the day that he was due to go turn himself in Louisiana. I don't know, but I can't continue to do the same thing. The good news for you, Mr. Mazel, is that it's Louisiana. So we have buses coming from Louisiana probably 2 times a week. So from the time that you waive, within the next probably 2 to 3 days, you'll be back in Louisiana to be able to answer the charge. But I'm not going to just continue to give bonds on fugitive cases when you continue to pick them up. Because
Got it?
Okay. Has he waived or did he refuse?
to refuse extradition.
Okay, so you need to decide what you would like to do. If you want to waive extradition, I would say probably within the next, 3 days, Louisiana will be here to come get you. If you want to refuse, which is well within your right, the state can get a governor's warrant, but that'll take 90 days. And at that time, they can have you remanded
I can
back.
sit in jail for 90 days. No, I'm not interested in that.
So, but I'll let you talk to James to figure out what you guys want to do, and then you just let me know.
Okay.
Now the stakes are clearly defined. This frames the legal exposure and sets expectations for the defendant immediately.
Mr. D.
Yes, sir, Your Honor. Your Honor, I'm trying to find out where are we with Sean Sullivan?
Sorry.
Yes, okay, Judge. Sean Sullivan, Judge, is my
You
understanding.
got it. Okay.
Yes, I have the case. I wanted to know, were you concerned with DVD? Did you want to get any DVD involvement?
Michelle? Yeah, this is the one that let's see this. Let's set it for a formal probable cause hearing. Okay. I'd like to do some additional research as well before I find probable cause in this case. So what I'll do is I'll put this case on for Wednesday for a formal probable cause hearing. In the interim, Mr. Sullivan, I'm ordering you not to have any contact with this person whatsoever. You understand?
Yes, sir.
I don't care what's going on in your life.
I got you.
For the moment, I'm gonna, I don't want you to have any contact. I don't want you to go where this person lives, where this person works. If I find that you do, I will revoke your bond, put you in jail.
Yes, sir.
We'll come back in 2 days. I would like to do some further research on, because, I really like to look at every case, do a deep dive to ensure that there's probable cause before we go forward. So, I don't blindly find PC for anyone. I'd like to do things in the fair way, but at the same time, I want to ensure that my county and every person in it is protected. So don't have any contact with this person. We're going to create bond conditions to this effect. They're probably going to reach out to her between now and Wednesday. And if they find that you're trying to communicate with her, it's not going to go well. You understand?
Yes, sir.
You mind filing no contact in the weapons, please?
Yeah, sure. No contact, I'm sorry.
No weapons.
No, yeah, sure. Thank you.
The You know, and one of the things that they teach us is, you know, never make rash decisions because it may be the wrong decision. And that's why I'd rather take a little bit of time before we do something to ensure that what we're doing is the right thing to do. So we'll put it on for Wednesday, come back Wednesday, and then we'll have a decision for you.
Thank you, Your Honor. Appreciate it.
I've given you a lawyer, so just stay in touch with Mr. D, and then we'll come back, and then we'll finalize it for you.
Thank you
okay?
so much.
Don't leave until you sign our bond conditions, okay?
Thank you. Thank you, Judge. Appreciate it.
We appreciate that some message files, they know what's going on.
Yeah, great. Maybe they can be here Wednesday to add anything further, and then we can.
This transitions into the factual basis of the case. Everything from this point builds the evidentiary narrative the court relies on.
Okay.
Judge, I am here on our friend. I feel like almost like he's family. Daniel Frazier.
Okay.
He was charged with another escape.
Oh, yeah, we got him back.
Yes, sir. Yes, sir. I was surprised to see him pull up on my docket as well, but not really.
Will you stay on it?
Yeah, I'm on, Judge. You know, we have a decent relationship. Even though we believe we know how this is going to go, at least from you, because right now the bond is set at $50,000 and $6, and $50,000 in the felony court. He wants me to ask you for a time served. I believe I already know what the answer is going to be. And in the event that you deny my request for a time served, he said he's willing to go back into treatment and he's willing to complete treatment this time. Now, I don't know how that's going to affect him upstairs because
Ours, until the upstairs is taken care of, because they won't take him with an open felony.
Understood.
Kind of
Understood.
standstill until.
And the big problem is I'm not representing him upstairs. But his court date is like May the whenever. It's like really far down the line. Yeah, so.
Get you going. Do you mind bringing up Mr. Frazier, please? Okay. Thanks. How are you?
I'm good.
You're back.
Yes, sir.
Good to see you. How are things? Good. What's good to see you?
We're good.
Say it again.
So they were good.
You know, you can run, but the long arm gonna get you every single time. You can only go so far. Sorry, no time, sir. You know how it goes. I told you, every time we come back, we're gonna do it until it takes. And, you
So
know,
my only option, in all honesty, my only option for this, for the misdemeanors treatment, there's no other option. No matter what. No matter if I got treatment on my own.
really? Really?
I mean, I've done it already. I've done it once. I've got behavioral treatment and I've also got mental health. Behavioral and also substance abuse treatment.
Yeah.
I've done both already.
I want to use ours. The problem is that I cannot do anything until the case upstairs is taken care of. So we're kind of in a holding pattern until upstairs. Hopefully, they will see that that's what we want to do here and they'll, you know, but I don't know. I can't, you're not representing upstairs, right?
No, sir.
So, we got to wait to see what happens upstairs. And then we'll just, told you, we're just going to keep doing it until it takes. Hopefully one day it does.
I really don't. I don't have a substance abuse problem. I really don't. And honest to God, I don't. Like I've stopped a long time ago. And honest to God, I've stopped, and I'm not trying to go that path. Honest to God, I don't have a substance abuse problem issue. I've stopped.
So, I guess let's set it for 30, Mr. Brooker. We'll wait. Because if they take care of it beforehand, you know, we'll see. And then if it's still set for the May 17th, we'll set it for the day after at that point. And then we'll see, hopefully, you know, reach out to the lawyer
I am, that's what I was
upstairs,
gonna
let
say.
them know this is what we want to do here. Hopefully they'll see that that's what we're trying to do. And then, you know,
So basically, I'm waiting for the felony, see what happens.
hopefully they will see what we're trying to achieve and be on the same page as us. You know, this is the second time you're facing this charge upstairs. They may offer you 4 years, 5 years upstairs. You know, it's no joke. You know, I'm trying to help you, Mr. Frazier, believe it or not. You know, really. You're facing a lot of time and it's not the first time. So if you try to, you know, we played this game the first time. I don't know if they're going to
Yes, sir.
So, anyway.
It's a different court, Judge, so I'm hoping that we can have a similar outcome. And if they do it beforehand, I'll come off
I
document.
want to do it, and hopefully if they see that you're really willing to. So, all right.
Yes, sir.
I just wanted to say hello. That's it.
Yes, sir. All right, thank you.
We'll see you in Thursday.
Confession after initial denial. This is often a turning point, in many cases significantly strengthening the prosecution's position.